Well, it's very important to me because it's the first case I argued before the U.S. Supreme Court, and I was kind of a young attorney at the time, and I wasn't quite sure how I would come out. But eventually, to make a long story short, I won the case. But it was about Congress passing a law saying that if you, any United States person, wanted to get mail from behind the Iron Curtain, which was not first-class mail. First-class mail was not affected by this law, but if you wanted to get second or third-class mail, which is periodicals mainly, you had to go to the post office and tell them that you desired to have that mail delivered, or else they wouldn't deliver it and they would destroy it. And so my client, Leif Heilberg, came to me and said he didn't want to go to the post office and put his name on some list, but he wanted the mail. And we felt that was reasonable because this was at still the height of the McCarthyite period. And if you had your name on a list of sympathizers, people who thought were sympathizers with the Russian and Soviet Union, you would be in trouble. So we sympathized with him, and we said we thought this law was unconstitutional. We had a trial before a 3-judge district court, which is the procedure at that time for challenging the constitutionality of a law. And we won the trial, so the government had to appeal, and they were given the right to directly appeal to the U.S. Supreme Court, and they did, and the Supreme Court accepted the case, and so I had to argue it, and it was really interesting. I don't know whether I told you last time about the good luck I had in finding a passage in a book. Okay, well, I'll tell you then. I was preparing very hard for this case. I had read all the transcripts and the legal arguments and the precedent cases, and I thought I was really up on it, and I just got to the point where I couldn't do anything more, and yet I felt I had to continue working on it because it was so important. And so I was in the law library. I couldn't look at my stuff anymore, so I just started to wander around, and I picked off a book randomly from the shelves of the law library, and it opened up to a page that had something pertinent to our case. It seems, and this book said, that in the period prior to the Civil War, the southern states and the southern senators were very concerned about abolitionist literature coming into the South. So they wanted to pass a law that if someone didn't want abolitionist literature, they could just put their name on a list and it wouldn't be delivered to them. And when this bill was debated in the Senate, it was defeated on the basis that it would be a violation of the First Amendment. So that was very interesting to me, and I kind of just noted it in my head. I think I made a note in my legal pad about it. When the case came up for argument, one of the first questions given to the Solicitor General, my opponent, Archibald Cox, was, Mr. General Cox, hasn't this occurred once before in the United States history? And he looked around at all of his assistants, and they all shook their heads, and he said, no, Justice Black, this has never occurred before in American history. So that gave me my entree when I got up to speak, because I was able to say, I'm not going to speak about anything that I have prepared here. I'm just going to answer the questions that the other attorneys were not able to answer. And I started off with that first one, telling the justices about that Civil War precedent that the Senate rejected because it violated the First Amendment. And I could see that they were all writing down this. It was very important to them. And Justice Black was very happy to hear that he was right, that it had happened before in American history. And it ended up that we won the case, I think, by a 6-3 vote. And it was the first time that an act of Congress had been declared unconstitutional because it violated the First Amendment. So that was a real landmark.